Dangote, you have enjoyed Nigeria. But at such a time when Nigerians are grueling under such hardship, you show a high level of insensitivity and you are sending this kind of document. What do we want to achieve by this? Let Nigerians hear the true position. When you're in a debate and it is opened, Nigerians are watching. Nigerians are listening. But you have chosen, for whatever reason and for whatever intent, to want to avoid coming to the House. The Federal Competition and Consumer Protection Commission invitation you're talking about was held after we had invited you and after we invited consumer protection here. And we scolded them that, in our opinion, they have slept on their responsibility. That's when they woke up and invited you people. And you thought it wise to attend their own invitation, attend invitations from public accounts, attend invitations from oil industries, but you will not attend to a critical matter that goes to the nerve and the pain of the average Nigerian. I don't know whether you watched that video of a lady that was residing under a bridge in Lagos in a flooded area because she could not afford decent housing. As air is to the human being, so is cement to the built environment. Sorry? To the built environment. And let me tell you, we owe you a duty of care. You are aware that under the ECOWAS treaties and African Free Trade Agreements, our borders are meant to be open for things like cement to come in 50 kg bags. What will happen if our neighbors begin to take advantage of these things? It will threaten your existence in the cement space. So it's in your best interest that you come to this table. Let us see how we'll review these prices down. Because I'll tell you on my honor, it is not about the few people you are employing that is our concern. We appreciate it, but we will not sacrifice millions of Nigerians that cannot afford to build houses or have decent accommodation for the greed just to pay salaries of a few. Implicated yourself. Because it is not for you to choose what you will come for and what you will not come for. This is the house of the people. You are obligated. It is not by choice. When you are invited by this house, you are obligated and it is mandatory that you cause appearance. That's number one. Number two, it's unfortunate and I find it rather a bit insensitive on the part of Dangote that, in my opinion, has been so nurtured by the Nigerian people. I am very aware of tax incentives, tax breaks, tax holidays you enjoyed, even under the pioneer status. While pioneer status is supposed to be on product, you enjoyed pioneer status on lines, on projects, not product, as against the intent of pioneer status. This government took an initiative to ban importation of cement so that we can have local production, because God has blessed us with all the mineral resources. But when capitalists take advantage of a system and wants to over-profit without any sense of empathy for the citizens that have given it this platform, I think it calls for a rethink of the position of the government. Your colleague has just left here, and they are ready to appear. Are they not cement manufacturers? A date we're going to give to them. Dangote, my ruling is simple. The law has given us the necessary powers. But just as I said, we owe you a duty of care. We're going to give you one more chance. We're going to communicate a date. Failure to comply with that date, and subpoena will be issued. A warrant of arrest will be given for you to cause appearance before the National Assembly. No single individual is bigger than the parliament of his country. No single Nigerian is bigger than the National Assembly and the People's Assembly. Honorable colleagues, we have written 4 letters. 3 to Dangote, and Dangote have vehemently refused to honor the invitation of the House, claiming that there is a substantiative suit against another committee, not this committee, challenging their right to appear before the parliament, which is their parliament. We did not stop here. We equally sought legal counsel from the National Assembly and other independent legal minds who have expressly said that the position held by Dangote and other members of Cement Association is foul of the law. We asked, is there a substantiative court order restraining the House from inviting you? No. None of such an order was produced to the House. Are you saying that the House that created you, because you are a creation of the Corporate Affairs Commission, which is a law created by the House, cannot invite you? And furthermore, the elected representatives of the House that were voted by you cannot equally invite you? You say the case is before the court. Which case? The case against the joint committee? Or is it the case against a separate committee where you join the House, where there is no ruling that you should not appear before the National Assembly, considering the fact that this country was built on the doctrine of separation of powers, where you have the executive, you have the legislative, and you have the judiciary. Dear sir, of course, addressed to the chairman of the joint committee, and please, Nigerians, take note. RE, invitation to submit memoranda and notice of preliminary hearings. We refer to your letter dated 29 June 2024 on the arbitrary increase in the price of cement by manufacturers of cement in Nigeria. As members of the Nigerian Employers Consultative Association, NECA, we have been advised of the position of NECA, which represents its member companies on this matter, per the attached earlier letters from the legal counsel of NECA to the joint chairman, Joint House Committee on Arbitrary Increase in the Price of Cement by Manufacturers of Cement in Nigeria. Also imperative to note is that we have been engaging the Federal Competition and Consumer Protection Commission and other official MDAs of the federal government of the same subject. As law-abiding corporate citizens of Nigeria and a member of NECA, the company will continue to uphold the rule of law to discharge its obligations. partner with critical stakeholders, and contribute to the country's growth and economic development. Thank you for understanding and usual cooperation. Foreign exchange that cement producers enjoy if they have any importation. Would want to know the status of the amount of foreign exchange in terms of purchase that they have enjoyed.
That cement fund was purely a fiscal matter. It wasn't a central bank issue. It was everything that was collected was due to the federal government. We will confirm if an account in the central bank was created for that purpose.
Who banks for the federal government?
We do.
Thank you.
But at the time, there was a period during the cement levy, I think, there was a period when federal government agencies were allowed to maintain accounts in commercial banks.
Even if these deductions were made from the customs?
Yes, sir.
They will push the money to the central bank?
Banks.
Who authorizes opening and operations of commercial banks?
We do, sir.
Right? So
we will
it's
get
all
the
under
report.
you. You can get us you're in the best position to get us that information.
We will get the report required.
Thank you very much. Actually wrote through some lawyer on the 23rd of April, invitation to an interactive session. This letter is in response to your invitation dated 20th March 2024 to Unlimited Cement Company of Nigeria. After the Court of Appeal, this is even Unlimited Cement. Okay, but it was, I believe, Dangote, dated 30th April, to Dangote Cement, a member of Employers Consultative Association, NECA. Dangote PLC, as a manufacturing entity, is a responsible corporate citizen of Nigeria with utmost respect for the rule of law. An appeal has been filed with the Supreme Court to determine the constitutionality, scope, and extent of Section 88, 89 of the 1999 Constitution on businesses in the private sector, following the decision of the Court of Appeal in suit CA 121-2014, NECA and 2 others versus Accountant General of the Federation and 5 others. What does this tell you? They went to the High Court, they lost. They went to the Court of Appeal, they lost. Which is to say, there is no substantiative order preventing them not to appear. You have gone to Supreme Court. That does not bar you from appearing. The people of Nigeria should be made aware of this level of insensitivity and lack of regard for the rules of law. And I mean, I do not think there is any other ground to even continue with reading this. Because funny enough, when I even checked, payment to the Supreme Court was made on the 22nd of March 2024. So, March. After invitations had already gone out in April. Quoting from, okay, this letter is response to invitation letter dated 20th March 2024. And we are now seeing a payment for Supreme Court dated 22nd March 2024.
After yes.
That's even after the letter.
Not to have smacked the whole in Nigeria.
This is their parliament. This is the parliament of the people. We owe them a duty of care. And we took our time and we wrote to the Director of Legal Services through the CNA. And of course, Their response is here, of which is a bit lengthy, but permit me to read just a few of their paragraphs. Section 89 of the Constitution, subsection A to C, categorically empowers each house of the National Assembly by itself or through any of the committees to summon any person in Nigeria, in court, to give evidence or produce any evidence or any evidence. It provides us to produce all such evidence, written or oral, directed or circumstantial, as it may think necessary or desirable, and to examine all persons as witnesses whose evidence may be material or relevant to the subject matter. To require such evidence to be given on oath, and C, to summon any person in Nigeria to give evidence at any place or to produce any document or other things in his possession or under his control, subject to all exceptions. That is quite clear. Now, the scope of the application of Section 88 and 89 is not limited to persons working in public sector only, but sections apply to all persons in Nigeria as long as it touches on an issue with respect to which the National Assembly is empowered to legislate upon. And in this case, the National Assembly in second schedule, part 1, number 39 of the Constitution, has been empowered to legislate on solid minerals, which is, of course, on the exclusive list. Note that the Constitution has given the National Assembly powers to compel attendance of persons who refuse or fail to attend after being called upon to do so. Section 89D of the 1999 Constitution, as amended, specifically empowers the National Assembly to issue a warrant to compel the attendance of any person who, after having been summoned to attend, fails, refuses, or neglects to do so, and does not excuse such failure, refusal, or neglect to the satisfaction of the House or the committee in question, and order him to pay all costs which may have been occasioned in his attendance or by reason of his failure, refusal or neglect to obey the summons, and also to impose such fines as may be prescribed for any such failure, refusal or neglect, and any fine so imposed shall be recoverable in the same manner as the fine imposed by a court of law. 7. Further states, furthermore, Section 89(2) of the 99 Constitution as amended states, a summon or warrant issued under this section may be served or executed by any member of the Nigerian police force or by any person authorized in that behalf by the President of the Senate or the Speaker of the House of Representatives, as the case may be. 8. Consequently, it is suggested that having followed laid down due procedure in inviting the cement producing companies, and they have failed or refused to appear, the House of Representatives may consider exercising the constitutional option granted to the National Assembly in compelling attendance. This is as provided by Section 89(1)(d) and subsection 2 of the Constitution. Submitted for your consideration, please, from Secretary of Legal Services. To this end, we further move that a letter be written to the cement manufacturers of Nigeria who have equally joined themselves in this matter, and we have invited and keep giving us the same excuse, that they must cause appearance on the next day, that we will communicate to them. Otherwise, we will invoke the provisions of this Constitution for them to cause appearance. Carried? Carried. In absence of any other, I guess we move for adjournment.